Welcome, everyone. This is State Senator Gustavo Rivera, and welcome to the our second town hall on the MRTA, or the Marijuana Regulation and Taxation Act. First things first, para aquellos de ustedes que hablen español, sepan que tenemos, si están viendo esto en Zoom, tienen un botón abajo que pueden darle para interpretación en vivo, para que puedan oír todo lo que vamos a decir en español. For those of you that, if you have folks that want to tune in who are only Spanish speakers, if they tune in on Zoom, you'll be able to do translation, interpretation that will be live. We will also be on Facebook Live, and we will be answering many questions over the next couple of hours. So welcome, everyone, again. My name is Gustavo Rivera, as I said, State Senator for the 33rd District in the Bronx, Chair of the Health Committee in the Senate, and one of the folks who proudly voted for the MRTA a couple of months ago. Now, as I said, this is the second in our series of town halls related to the MRTA. The first one, which was a very successful one that we did a few weeks ago, was related to the economic opportunities that would be available as the marketplace for legal cannabis opens up, hopefully soon. We'll talk about some of the issues that are coming, we have difficulties with that, but that was the first one. The second one will be specifically related to knowing your rights, because let's back up for a second. As I said, I was one of the folks who proudly voted for the MRTA, or Marijuana Regulation and Taxation Act, and the reason that I voted for it, at the core of it, it was a social justice type of piece of legislation. It was a restorative justice piece of legislation. The notion here was that we recognized that the drug war had been so harmful to communities of color for such a long time that we needed to be proactive in the way that this bill was structured. So that means that we included restorative justice measures in it. We made sure that looking backwards, we could talk about folks' records being expunged, and we'll certainly be talking about that tonight. And we'll also talk about the economic opportunities that we wanted to make sure were available to people, some of whom might have been involved in the illicit trade before, as we go forward. And lastly, we wanted to make sure that the revenue that was a product of this, once it goes into effect, goes into the communities that have been harmed by the drug war over generations. So all of these things were in this piece of legislation, which is why I'm so proud. I was so proud to vote for it. Now there is now the MRTA, once it goes into effect, it is already law, but it has to actually go into effect. There's kind of a little hiccup here, and the hiccup is that there has to be a nomination of both an executive director of the Office of Cannabis Management and a director for the Cannabis Control Board. Now these are the bodies, so to speak, that are going to regulate in the state of New York going forward the adult use cannabis program, as well as the existing medical marijuana program, and also the existing cannabinoid hemp program. This is for fibers and such. So we're going to be, so tonight we're going to be talking specifically, as I said, for folks that are interested in the economic opportunities that are available. I would want to actually drop a link in the chat, or I want to put it somewhere in here, because we actually have that as a Facebook. We did it as a town hall, but it is recorded, and you can actually go to watch it. It is on Facebook. It'll be there forever, and you can actually go and see all the different economic opportunities that exist because of that. So it will be available both in the Zoom chat and in the Facebook comments. So if you have not seen that, that is where you will go see it. But tonight we're going to be talking about something a little bit different. We're going to be talking about what the core of this is, the knowing your rights. We're going to be talking about automatic expungement. This is for folks who were involved in the illicit trade before and have a record because they were arrested and convicted of cannabis-related matters, marijuana-related matters before this came into effect. And by the way, just as a quick parenthesis, and I'm sure this will be said by the panelists as well, but if somebody says that they can get you a marijuana-related record expunged by you paying them, they are scamming you. Okay, so let's make sure that we say that, and I'm sure that the panelists will underline this. So make sure that you do not fall for scams. And also, we should be aware that there will be some slightly the situations will be slightly different for those folks who have immigration issues. So we wanted to make sure that we had an expert on hand here that can actually talk to us about how this bill impacts, or this law, I should say, it's not a bill anymore, it's a law, it's been signed into law, how this law impacts not only just everybody, but folks who are immigrants and who have some immigrant issues. So we want to make sure that some immigration issues. So we wanted to make sure that we covered all of that. So that we'll be talking about tonight, and we will have an opportunity, just like we did in the first town hall, to answer a whole bunch of questions. It was a very productive session first time, so I'm sure it will be this time. And I will be introducing you to your panelists and getting out of the way so that they can tell you some of the facts about knowing your rights in this new post-MRTA passage environment. And then we will come back to answer some questions, some of which have been sent in already, and some of which will be generated by the discussion that the panelists bring forth. So I'm just going to introduce all of them now. As we introduce them, we're going to pass it off to them. We have Eli Northrup, first of all, who's been working at the Bronx Defenders since 2015. Big fan of the Bronx Defenders over here. He handles both felony and misdemeanor cases and is a member of the policy team at the Bronx Defenders. And he also served as the E. Barrett Prettyman Fellow in the Criminal Defense and Prisoner Advocacy Clinic at Georgetown Law School. So obviously somebody who knows his stuff right here from the Bronx. Joining him will be two more folks. One of them is Emma Goodman. And Emma Goodman is staff attorney for the Special Litigation Unit at the Legal Aid Society. She began her career as a public defender in Manhattan. Therefore, she saw a lot of the criminal system there, and actually was very instrumental in passing the first ever automatic expungement law in 2019. And she recognizes that automatic expungement is key to addressing criminal injustices, I should say. And we should say that more than 500,000 cases have been expunged already statewide, a lot of it having to do with her advocacy, a lot of other folks too, but certainly her advocacy was important. And last but not least, we are joined by Jose Chapa. And Jose Chapa works at the Immigrant Defense Project as their senior policy associate, focusing on state policy, legislation, and advocacy. Before this, as somebody who certainly knows how to gain a legislative win, he was a legislative campaign coordinator for the Justice for Farm Workers campaign, which was a successful effort for the passage of the Farm Workers Fair Labor Practices Act of 2019. And certainly knows about difficult issues on immigration matters, since he comes from the Rio Grande Valley out in Texas, and he is now with us here. And so let's welcome all of them. That is Eli, Emma, and Jose. So as I pass it off to them, I will say thank you so much for being part of this evening. Make sure that you get your questions ready, and I am looking forward to continuing to have a conversation. Folks, over to you.
Thank you, Senator, and thank you to everybody who's watching either in the Zoom or on Facebook. We really want to serve as a resource here and answer questions you have. So if you have questions, please put them in the chat. Let us know, and we'll try to get to all of them. We have a slide presentation that we're going to use, but I just want to initially reiterate what how enormous this piece of legislation is, the MRTA, and thank the senator for his efforts in getting it passed. A few years ago, there was a push to make marijuana legal, and the bill at that point would have been nowhere near as robust as the bill we ended up with. The MRTA goes farther than any bill in the country in terms of addressing, previous harm done by the criminalization of marijuana, providing for investment in communities, opportunities for people who have been affected by the war on marijuana to participate in the new economy, and really, automatic expungement and really making marijuana legal. So as soon as we get our slideshow up, I'll continue with our presentation. Thank you. And you can go to the next slide. So the Marijuana Regulation and Taxation Act was signed into law on March 31st of this year. And just to be clear, while certain provisions in the bill need to wait for the Office of Cannabis Management and the director to be appointed. The criminal penalties provisions, the collateral consequences provisions, the automatic expungement provisions that we are talking about are all in effect right now and have been in effect since March 31st. So almost everything we're talking about right now is currently in effect. So what does it do? A basic overview. The MRTA allows the adult use of cannabis. It makes it legal, akin to alcohol. It automatically expunges certain past convictions and creates vacature for others. It addresses collateral consequences in a number of areas. And as the senator mentioned, it creates equity programs, providing loans and grants to ensure opportunity for participation in the new industry. And it dedicates 40% of the tax revenue from cannabis sales to those communities that have been disproportionately impacted by the war on drugs. So that's a general overview of the act. Tonight, we're going to talk really about the know your rights portion. So the changes to the criminal penalties, collateral consequences, and implications for non-citizens, and the automatic expungement provisions. So what were the changes to the criminal penalties? Under the new law, anyone over the age of 21 can possess up to 3 ounces of cannabis inside or outside of their home. That's legal. Eventually, you'll be able to possess up to 5 pounds in your home. That's one of those provisions that needs to wait until the Office of Cannabis Management develops its outlines for home grow, because you will also be able to possess up to 6 plants in your home as well. But for now, it's 3 ounces inside or outside of your home, unless you have it prescribed by a doctor, in which case you're allowed to possess more. People can also smoke cannabis where they could otherwise smoke a cigarette. So, outside on the street, in most areas, not in parks, not in restaurants, where you could smoke a cigarette, it's okay to smoke cannabis. You can also give lawful amounts of marijuana or cannabis, so up to 3 ounces, to other people who are over 21. As long as you're not selling it, it's lawful to give up to 3 ounces. Next slide. So here's a little chart that kind of just outlines what the new law looks like. And it says that you can possess up to 3 ounces totally legally. Above 3 ounces, but under a pound, 16 ounces, is a violation. So that's not a criminal offense, actually, but it is. It's not technically legal, and you can be fined up to $125. Now, possession of more than a pound is a Class A misdemeanor, and you could face criminal penalties and jail time of up to a year. Possession of more than 5 pounds is a Class E felony, which includes potential prison sentence, and more than 10 pounds is a Class D felony. But essentially, you can possess up to 3 ounces totally legally and up to a pound before it becomes a criminal offense. Next slide. So what happens if somebody under 21 is caught with cannabis? It's no longer criminal. It's a civil penalty, and there's a fine that's associated with it, but the fine cannot be more than $50. And that penalty is prohibited from carrying collateral consequences or resulting in forfeitures of rights or privileges. The idea is obviously not to encourage youth use, but to ensure that if youth are caught with cannabis, nothing happens that will hurt them, going forward in the future. And so those are the penalties for use under the age of 21. There's also now limits on when cannabis can be used if somebody's on probation, parole, supervised release. Essentially, it can no longer be a violation of any of these release programs to use cannabis unless it's explicitly mentioned in the terms of the release and that its cannabis use was actually related to the crime of conviction. So it's no longer can just be a blanket policy that parole or supervised release or probation can test people for the use of cannabis. Instead, it's only relevant if it's actually related to the crime of conviction, and that needs to be demonstrated in order to do it. Next slide. So here's a chart with the new sale offenses, because it's obviously illegal to sell marijuana without a license. But right now there's no licensing structure set up. That's going to take some time before that goes into effect. So in the meantime, these are the new criminal sale offenses. It's a misdemeanor to sell marijuana, cannabis to somebody under the age of 21. However, there's a defense to that if the buyer and the seller are within 3 years of each other. So for example, if somebody who's 22 sells an amount to somebody who's 19, that would actually not be illegal. Otherwise, it's illegal to sell any amount of cannabis without a license, but it's not a criminal offense. It's a violation. So it comes with a fine, but it's not a crime. Selling more than 3 ounces to somebody is a criminal offense. So just like selling more than 3 ounces is a Class A misdemeanor, selling to somebody who's under the age of 18 more than 3 ounces is a felony. So selling to somebody who's 17 is a felony if you sell more than 3 ounces. However, there's that same defense that I mentioned earlier in the law. So a 22-year-old selling to a 19-year-old more than 3 ounces, there's actually a full defense. Selling more than a pound of cannabis is a Class E felony, which carries potential prison time. And you can see the other felonies that are associated on the chart. Next slide, please. Some other really important changes that are contained in the law. And this was a hard-fought change that only really exists in this new law in New York. The odor of cannabis can no longer be used as a basis to stop and search people. It explicitly says this in the new law. You know, what we saw as public defenders all the time is police officers justifying stopping people, searching people by saying that they smelled the odor of marijuana. Whether or not they actually found marijuana, they would use this as an excuse. And, you know, it's a thing that doesn't show up on a body camera. It's something that's very hard to disprove. So we saw it as almost the go-to rationale, and police can no longer use that rationale because of this new law. So they won't be able to use the odor of marijuana as a basis to stop and search people. There is a small exception to this if they are investigating a DWI offense, because it's still illegal to drive while impaired by cannabis or the combined influence of cannabis or alcohol. The law didn't change with respect to that. So think of, you know, cannabis, much like alcohol, it's still illegal to drive while you're high or impaired. Stay on that slide for one more second. A lot of people have questions about whether or not they can smoke in their car. Cannabis was added to the open container portion of the law. So technically, just like you can't drink a beer in your car, even if it's parked, you can't smoke in your car. It's not a crime, but it is a traffic infraction. It does invite police interaction. So do not advise people to smoke inside of their car if it's on a public highway. Now, if you're in a private driveway, you can do whatever you want. But if you're on a public street smoking, it's still technically against the law. But in most events, you can just step outside of your car and smoke directly on the sidewalk outside of your car. So something to know, because there's a lot of questions about that. Okay, we can go to the next slide. Just briefly to addressing collateral consequences. In the new law, in the MRTA, it specifically prohibits discrimination for using cannabis in lawful amounts in a number of contexts. So in the housing context, the education context, the employment context, applying for a professional license, getting medical care in the family regulation, child welfare system. Using cannabis in amounts that are legal cannot be used to discriminate against you in any sense. Now, there are small exceptions because cannabis is still illegal at the federal level. And Jose will talk about this a bit more when he discusses immigration consequences. But we have this, you know, obviously at the federal level, cannabis is still technically illegal. So if a landlord is receiving a federal benefit, unfortunately, they can still have a policy that prohibits you from growing or possessing cannabis if your landlord is receiving that benefit. Private landlords can also prevent you from smoking in an apartment, just like they can prevent you from smoking cigarettes. So that's a contractual issue. Also, in education context, you know, if the school would lose a federal benefit, if there's a religious reason, they can actually use cannabis to discriminate. In employment, generally, drug testing for cannabis is no longer allowed for denying a job. However, you know, if it's a federal job, they're not bound by that. I will just say they can still drug test you for using cannabis on the job, just like they can drug test people for using alcohol on the job. But this is more about when you're applying for a job, whether they can drug test and discriminate against you for cannabis use. I'm going to speak about the family regulation system in a little bit more depth. If we can go to the next slide.
Before you do so,
Yes.
so, just really quickly on this, to linger on this one for a second, because there's a question from Jen Lowing, and that is, if recreational use is federally prohibited, what are the implications for users who are in regulated professions, like a RN or a doctor or a physician's assistant, etc.?
I'm not the absolute best person to answer this question, since it's more focused on, this is more focused on the criminal aspect, but any federal regulation takes precedent. So if you're federally licensed and there's a federal prohibition on use, unfortunately, the MRTA cannot override those federal laws. At the state level, the state is basically saying, for state licensing, cannabis is no longer relevant in these contexts. But if it's a federally regulated job, then you're bound by the federal regulations. And I hope that's helpful.
Yeah.
I don't know, Jose or Emma, if you have anything else to say about that I missed.
It's absolutely helpful, because I wanted to make sure that the preemption still applies. Federal government still has preemption. And so in cases where there's a federal job, it's a little bit different. But I just wanted to make that distinction, particularly since Ms. Lowing wanted that answered. Please continue.
Absolutely. And I do see another just question in the Q&A. Will NYCHA residents be able to home grow? Emma, I think, might address this a bit, but essentially, because NYCHA receives federal funds, NYCHA can choose to prohibit that. So it remains to be seen, because the home grow regulations have not been, yet set forth. That's something that is yet to come, but NYCHA would be able to prohibit home grow. Emma, do you have anything to add to that?
No, that's what I was going to say as well. I think it is unlikely, but like Eli said, we'll see. Maybe we'll be pleasantly surprised, but it's unlikely if you're in NYCHA property that you'll be able to home grow or consume.
Thanks, Emma. Okay, so just the family regulation system, the family regulation system provisions that are contained in the MRTA. So this is basically, when ACS gets involved with a family, how can cannabis use be used? It used to be that cannabis use alone could be the basis for a finding of neglect. And actually, we see all the time in the Bronx, families being separated because of cannabis use. That can no longer be the sole basis for separation of families. And it can't be the sole basis for custody or visitation or loss of parenting time either. So that's a really groundbreaking provision. It's basically treated like alcohol now. It's legal. So the use of cannabis alone cannot be a reason to separate families. And if a family or a parent had a previous finding of maltreatment based on cannabis use alone, and they were placed on the state central registry, they can now apply to have that sealed. And if you think this might apply to you or know somebody, please reach out to the Bronx Defenders, the Legal Aid Society. Actually, you can reach out to the Bronx Defenders in a case like this, and our contact information will be at the end of the slide, and we can help you to try to get that sealed. Next slide. So I'm now going to pass it off to Jose, and I obviously will be here to stick around to answer questions at the end.
Thanks, Eli, and thank you, Senator, for having this important presentation. My name is Jose Chapa. I'm the Senior Policy Associate at the Immigrant Defense Project, and I'm going to focus my portion of the presentation on how marijuana still impacts the immigrant community in New York and across the country, but just kind of starting off by letting folks know that marijuana-related arrests have fueled an arrest to deportation pipeline in New York, as arrests and convictions have triggered immigration arrests across the state in the past. And that's why with this new law, it's very important for immigrants to understand the remaining possible negative consequences of marijuana-related activity. It's especially important to do outreach to immigrants because as you'll see, they'll need to decipher the mixed messages of what marijuana legalization means. So, as Eli described, a lot of marijuana-related activities no longer criminalized by our state criminal laws, but ultimately the advice for immigrants that we want to let folks know is that you are the person who makes the ultimate decision about marijuana-related activity based on the risks and benefits to you. Please seek out, and this is very important, if you have questions, if you're an immigrant, if you have very specific questions about marijuana and how this might treat any past case you might have, is to seek out advice from an attorney in order to get those answers for you, keeping in mind that each individual has unique circumstances with regard to their immigration situation and history, medical conditions, stressors, and risk tolerance. Next slide. Well, just to start off with, the primary thing we have to think about is where you were born. People born in the United States are considered U.S. citizens. This is hard and fast rule determined by the Constitution of the United States. So if you're born in the U.S., you're a citizen, and you have to go through a very complex process to renounce citizenship. Everyone else, technically, that is not born in the United States is technically an immigrant. And just for the sake of time, we can't really talk about all the different statuses that are a part of that, but that's something to just distinguish that everybody born outside of the United States is technically an immigrant, and everybody falls under different statuses. Next slide. And again, this just kind of exemplifies the different statuses that folks might have. If you're born out of the United States, you could be a lawful permanent resident. That means a green card holder. You could be a naturalized citizen. Undocumented people also fall into this category. DACA recipients, different visa holders, temporary protected status. It's a very complex system, as folks probably know, and for the sake of time, we won't go into every detail, but everybody that isn't technically a citizen could be at risk of possibly getting in trouble in the future if there's still a marijuana conviction. So we'll go to the next slide. So to understand immigration law and policies, marijuana-related activity that is legal in New York or any other state can still result in adverse immigration consequences. So this next section is about immigration laws and policies that impact that risk. It is important to distinguish laws and policies so that community members can understand the changes in the future that may impact them. And this goes, again, in the past, a lot of laws were passed in the United States and made marijuana an illegal substance, and it's still in place federally, even though here in New York, now it is a legal substance. Next slide. Even though medical and recreational marijuana is legal in New York, marijuana-related activity can still pose immigration risks because of the mismatch between federal and state law. And again, this goes along with the fact that immigration law is just very complex and complicated, but the fact that marijuana remains federally illegal can have very drastic consequences to any sort of application or any sort of status that a person that is not a U.S. citizen might have in the future. Next slide, please. These are just some of the examples of which laws impact immigrants directly. So it's the Immigration and Nationality Act, Controlled Substances Act, the Schedule of Controlled Substances, another act. So all these are different laws that have that could potentially impact immigrants across the country in relation to marijuana. Marijuana is on a list of drugs with acceptable uses, along with heroin and cocaine and a few other drugs. So that means that marijuana is federally considered something that you should never have for any reason, medical or recreationally. And that still is the case on a federal level. Next slide, please. Under immigration law, negative consequences may come from a conviction for a controlled substance offense, legal admission under oath to violating any law related to controlled substances as defined by the Controlled Substances Act, including federal laws, evidence that supports a reason believing that an immigrant is or has been involved in illicit drug trafficking. And this can be confusing if you're granted a license by the state of New York to sell marijuana, for example, or if you're otherwise in a legal business that is related to the marijuana market in New York. You won't think of yourself as an illicit drug trafficker, but again, the mismatch in federal law means that you're included here. So next slide. Immigration risk of marijuana. When will you be questioned about drug related activity? So if you're in the immigration system, you're applying for immigration benefit, including lawful permanent residency or citizenship, or maybe you're returning from a trip abroad or testifying in immigration court, you could be questioned about any potential usage of marijuana. And again, that could be trouble. That could spell trouble. The federal government is not going to be staking out your local dispensary whenever those open up in New York to see who buys marijuana. But as the policy is right now, is to ask you about this activity in a few different times when you're interacting with immigration officers. So if you're applying for something, so you're applying for, as I said, residency or citizenship, these are questions that you could potentially be asked. Or more than probably you will be asked by immigration officers. When you're coming back from an international trip, maybe you went on vacation, you want to see some relatives for a wedding or a funeral. When you come back into the U.S., Border Patrol could ask you about any sort of question about relating to marijuana. Or if you're in deportation proceedings, you may have to testify in court. This could also come up in court if you're testifying in your immigration court proceedings. So these are questions that can be brought up by immigration officers because, again, this is still a federal substance that is illegal. Next slide, please. And there's a lot of different things that come up as well. Social media posts relating to marijuana activity, that could be something that could pop up. For example, if you are coming back into the country, technically immigration officers could get your phone and look at your social media posts to see if you have any marijuana activity in any of those photos. On your cell phone, for example, they could look at your cell phone as well. If you have applied for a medical marijuana card for a child or someone else you're taking care of, or for yourself, all these things could be used against you if you are in the process, in deportation proceedings or any sort of other process to try to get status in the U.S. So these could all of these examples can be used against you by immigration officers. Expunged convictions that have not yet been vacated by the court, and we'll be talking a little bit more about that in a bit, is another example of other marijuana-related activity that could be used against you by immigration officers. Next slide, please. Why would I tell an immigration officer about my marijuana-related activity? Well, if you are in any sort of proceeding or you are applying for any sort of application, you are required to provide information under oath in order to get an immigration benefit. So these are questions that you technically would get asked by the application process itself. So that's something to keep in mind as well. Next slide, please. Vacating convictions for immigrants. So on a note of immigrant, people often think that only undocumented people are at risk of deportation, and this is simply not true. People with immigration status, so that includes people that are lawful permanent residents, people with green cards, there are all people that are, in the DACA system. These are all folks that are potentially at risk of deportation. Immigration status and criminal history can be sensitive. It is best practice not to ask people to volunteer their status or arrest history in group settings unless you've created a community of trust and safety for sharing confidential information. And this goes for any group setting, any anywhere. These systems are complex. Not everyone knows their immigration status and exactly what they've been convicted of. It is helpful to be able to refer community members to a reputable legal service provider when they are unsure, because this is, again, a very complicated system that we're dealing with, especially when you're dealing with eviction. Next slide, please. And then immigration consequences of convictions. Again, this can be the basis for deportation. It can deny folks citizenship. It can deny folks, it can be the basis for immigration detention during deportation proceedings. So there are still, again, a lot of consequences that come along with any sort of marijuana conviction. And again, since this is still a federally illegal substance, this can have a lot of consequences for folks in any sort of system trying to get status or anything like that. Next, a mismatch between state definition and of conviction and the immigration law definition of conviction means that even though a conviction may be expunged by the state, it can still result in negative immigration consequences. So, and Emma will talk a little bit more about the vacatures and what that means and how to get, in order to actually have your conviction not be impactful in court, you must not just get that conviction expunged. You also need to get it vacated. And again, that's just why it's very important for folks that are worried about this to talk to an attorney to help you with this process, because it is a complicated process. Next slide, please. And here are two examples of individualized vacatures. One, expanded access to court review for people who may suffer immigration consequences despite an expungement, presumption in the law that your conviction is not valid, but prosecutor can present evidence that the conviction was valid. And if you win, your conviction can be erased. The other example is resentencing, available to almost anyone with a New York marijuana conviction. You can make a special motion under this law if you need the change to be effective for immigration purposes. Court can substitute an offense for your old convictions, but you can also argue your convictions should be erased. And again, in order for you to get this, any vacature from your old conviction, you need to talk to an attorney because this is a complicated process. And next slide, please. Post-conviction vacature motion process, as I mentioned, is very complex, and to determine which vacature is more appropriate or whether or how it can help an immigrant, an attorney must understand the client's complete criminal and immigration history. They must prepare the case carefully so that the federal government cannot argue that the vacature didn't actually erase the conviction for immigration purposes. And the attorney must understand the possible immigration consequences of any new plea or sentence. The government may try to use statements made in the initial motion papers to make arguments against the immigrant in immigration court or to deny an application, but a good attorney will investigate all avenues for overturning a conviction, not just for those based on the MRTA, to ensure a client has the best chance of achieving their goal. And again, one of the great things about this new law, the MRTA, is that convictions can be overturned and expunged, but you also need to get that vacature in order for you, if you are in the process of any immigration process, to get that settled before you can move on with your case. Getting a vacature that is valid for immigration purposes can be complex. Even if these forms online look simple, you should work with, again, an attorney that understands the immigration requirements. And finally, record destruction. The MRTA allows individuals to petition to completely destroy the records related to marijuana convictions that are expunged, but this is not always a good idea. Immigration keeps its own files on you, so immigration officers may still want to know about the conviction even if the state record is destroyed. You need the record to be able to vacate it later. And again, this is the moral of the story is, if you are an immigrant and you are very unsure about what to do about your old cases, if you have one with marijuana, the best thing to do is to talk to an attorney in order to get these the vacature process started. And Emma will talk a little bit more about that. Thank you. I'm going to pass it on to Emma now.
Good evening, everyone. Thank you again for being here. Feel free to ask questions as we go through, and we'll also answer them later if we don't get to them. I'm going to talk about automatic expungement and vacature. So the MRTA, we're calling it marijuana justice because that's really what it is, created automatic expungement. This means that you do not need an application. You heard the senator say this, but I just want to reiterate, you do not need to apply for automatic expungement. It's automatic, meaning it just happens, the court does it. You don't need to do anything to make it happen, and you don't need a lawyer. Next slide. Expungement, when we talk about expungement and clearing people's records, it's really significant that it's part of this bill because it really is an issue of racial justice and economic justice. So when we look at the people that are discriminated against, both in terms of how they are prosecuted by the DAs and how they are arrested by the police, and also who's discriminated against once they have a record, it is the vast majority of people are Black and Latinx. And when people are discriminated against based on their criminal conviction, they lose on average $484,000 in their lifetime that they would have made if they didn't have a public criminal record. That number goes way, way down if the person's record is sealed or expunged. So it really changes your ability to provide for yourself and your family because you're no longer being seen for your record, you're being seen for who you truly are. Next slide. So this is who is eligible for automatic expungement. It is anybody with one of these convictions listed on this slide. The kind of quick reference is anybody that was convicted of possessing up to a pound, 16 ounces, or selling up to 3 ounces. Those, if you'll remember when Eli was talking about the criminal penalties, are the things that are no longer crimes. So they're either completely legal or they're violations and not crimes. It's this list of offenses. One thing that we were talking about earlier was the need to know exactly what's on your record for immigration purposes. The same is true for expungement and all of these things. If you don't have a copy of your record, it is good to get one, and then you'll know exactly what's on there and you'll know what kind of relief you're eligible to get, because you need to know exactly which offense you have on your record, and you probably won't remember exactly which PL, meaning penal law offense, you had. There are no restrictions based on eligibility other than that you have to have that offense. You don't have to be out of prison. You don't have to not have any other convictions. It's just you have that offense, it's getting expunged, that's it. Now, what does it mean when your record's expunged? It means that your case is vacated, dismissed, and deemed a nullity. It's like if you go to court, you get in front of the judge, and the DA says, I'm dropping the case, I'm actually not going to prosecute you. Or you go to trial and you win. What happens to your case ends up being exactly the same. If you are asked about whether you have a conviction on a job application and your only conviction was for something that was expunged, you can answer no. There is an exception. Sorry. I apologize. There's an alarm outside. That's what you get for being in Queens. There is an exception if you are applying for a gun license or if you're applying to be a police or a peace officer. That will still show up for those purposes. Your case should not show up on a background check, and it shouldn't be used against you in any of the circumstances that Eli was talking about when he was talking about the collateral consequences that this bill tried to address. So that includes ACS proceedings, shouldn't be used against you in housing. And one important thing to note is that the expungement records already should be suppressed. They shouldn't be showing up already. Let's move on to the next slide. So this is actually what happens. The Office of Court Administration and the Division of Criminal Justice Services are the two agencies in New York, they're state agencies that hold all of our criminal record information. So the Office of Court Administration has all the information from the court side. Division of Criminal Justice Services is where your rap sheets come from. So they kind of hold all the information that then gets sent out to places when they request a rap sheet. They both will identify the cases that are eligible by looking up the penal law offense, and will enter a code into their computer systems that will mark those records as expunged. They have until March of 2023 to actually officially expunge the records, but any 221 offense, so there are a couple that are not 221 offenses, any 221 offense, which is almost all of them, is already not showing up on a background check. They've already entered what they call suppression codes, which means that those cases will not show up as of now. So you can be comfortable saying that you do not have a criminal conviction if you're going and applying for a job that doesn't fall under one of those exceptions, which is law enforcement. Law enforcement and prosecutors will then get a notification sent to them by Albany telling them that the records that they have must also be marked as expunged and treated as though they are expunged records. There's a link here on OCA, that's Office of Court Administration. Their website has a lot of information about what expungement means and how it works. So go there, or you can reach out to us, of course, for more information. Next slide. One thing that's been coming up a lot is that people want to make sure the record actually has been expunged. Fair enough. There is no simple process to do that that's just for the MRTA. What you can do is you can request a copy of your certificate of disposition from the court where you were convicted. You can also request a copy of your fingerprint-based rap sheet. Either of those will show what the record is actually showing at both agencies, and you'll be able to see that it's actually been expunged. There's information about how to request both of those things on our website, and there will be more information about our website later on in the presentation. Next slide. So Jose mentioned this briefly. You are able to request record destruction if you have a case that's eligible for automatic expungement. That's not necessarily a good idea. It could be dangerous for a number of reasons. Immigration purposes is one of the main ones. But just think about how many background check companies are out there that might make a mistake. And you're applying for a job and the record pops up. And normally what you would do is you would go to the court and you would get a copy of your record and you would show it to the employer and say, this was a mistake. I don't actually have a record for that. And that would be, and hopefully you would get the job. And legally you would be allowed to get the job based on that. If you can't show proof of what happened with your case because the record doesn't exist anymore, then you could end up running into problems that make it worse than if you just let the court retain a copy of the record and then had access to it just in case when you need it. So just consult with a lawyer before you decide to request the destruction of your records to make sure that it's actually what's best for you. Next slide. So automatic expungement is automatic, but there are a number of things that aren't automatic that may require a lawyer. One of them, as Jose discussed, is if you are an immigrant, you may still need to file an application to vacate your conviction. You should definitely speak with an immigration lawyer about that. If you have a conviction that's not eligible for automatic expungement, I'm going to briefly talk about applying to vacate or reduce your sentence in the next section. If you're considering the physical destruction of your records. And of course, if you're looking to seal or expunge something that is not a marijuana conviction, there are other laws out there. That's one of the things that I do is represent people in sealing cases. Reach out to a lawyer and find out if you might have options to help with your other cases too. Next slide. So I'm just going to briefly talk about applying to vacate convictions. There are a few different ways that you can vacate your convictions under the MRTA. The one that I'm going to talk about is one that is not mainly for immigration purposes. It applies to everybody. It's for people mainly that have a marijuana conviction that was not eligible for automatic expungement, which means possessing over a pound or selling over 3 ounces. for people, almost everybody, you will be eligible to apply, which means you'll have to file an application to the court to vacate your conviction or get your sentence reduced. There's almost no difference between expungement and vacature in terms of what happens to your record unless you're an immigrant. The big difference here is that you need to apply to vacate your conviction, and the expungement is automatic. You don't need to apply for anything. Next slide. These are the convictions that are eligible for vacature under that provision. As you can see, it's essentially everything other than possessing over 100 pounds of marijuana. Everything else is eligible because everything else is now a lower level offense. And this is basically a way for people to get their conviction changed. So if you had a felony conviction, but now that same level offense has been downgraded to a misdemeanor, then you could apply to have your conviction changed to a misdemeanor, so you no longer have that felony on your record. Convictions that are eligible for automatic expungement and have been expunged are also eligible for vacature under here, but unless you're advised by an immigration lawyer to file a 440 motion, you don't need to apply to vacate your conviction for something that was automatically expunged. If a lawyer tells you that your record was expunged and you are a US citizen and that you should still file a 440 application, do not give them money and do not believe them. It's not necessary. It's not going to make a difference in your case. It's just a waste of your time and your money. Next slide. Here are a few examples of why you might want to file an application to vacate. The main one is that you have a felony conviction that's now a misdemeanor, as I discussed. This is pretty straightforward. There are also a few changes in the law. So it's essentially anything that is no longer criminal or is that a lower level offense. So if you have a sale conviction where there was no compensation, meaning no money was exchanged, under the old version of the law, that was still a sale of marijuana. It is no longer a sale. Now it is just sharing. It's not illegal. You might want to apply to vacate. If you still have other charges that stand, you might want to request a reduced sentence. And this is a very specific one, but Penal Law Section 221.45 used to be, or it was, sale of up to 4 ounces of marijuana. It's now no longer a crime to sell up to 3 ounces of marijuana, but they're not automatically expunging those old convictions. So if you're one of the people that has that old conviction and you can show that you sold under 3 ounces, your conviction should be vacated. You shouldn't have anything on your record for that because it's no longer a crime. Next slide. Here's the process that you would use to apply to vacate your conviction. First, find out what your record says and confirm that you actually have a conviction that's eligible. There is a court form online. It can be found here. It's at the NY Court's website. It's in the same area that you can find the information about expungement. You can fill that out and file it. You should be able to do this without a lawyer. If there is a hearing, and there may be a hearing because the DA can't oppose it, request that the court assign a lawyer to you. If you don't request that the court assign a lawyer to your case, they may not give you one and you may have to have a hearing without a lawyer to help you. If you request one, they will almost always give you one. So definitely make sure you do that. There's a mistake in the law right now. So as the law stands, there's a typo. The Senate has already introduced something that would fix the typo, but it is unlikely that it will be fixed before January of next year when the Senate and the Assembly come back in Albany. Under the current law, you must be able to show that you're experiencing severe or ongoing consequences related to your conviction or sentence. This was mainly put in because if you were experiencing immigration consequences, then of course, that is severe and ongoing if you're facing potential immigration consequences. But there could be other times when you would be facing severe consequences. For instance, I just spoke with somebody that had a felony marijuana conviction and had a new case and was being sentenced as a second felony offender, which means he was getting a higher sentence on the new case because the old marijuana felony was still a felony on his record. If that were a misdemeanor, his sentence on the new case would be much lower. That's obviously a lot of time in prison that he could get back if he can get rid of the old felony. So that's a severe consequence too. The mistake in the law is that you have to show that there is a severe and ongoing consequence at all. The point of the law was supposed to be that you wouldn't have to even show that, and you would just get resentenced to a lower level offense. So if you have a severe and ongoing consequence right now, and you want to apply for vacature or resentencing, you should go ahead and do it. If you don't, if you're generally doing fine, then I would wait until January, and then you should be able to get this benefit without having to show all of that stuff, and it should be much easier. But for now, it's going to be a little more complicated. Next slide. All right, and that is it about expungement and vacature. Just to reiterate, the expungement is automatic. The vacature requires an application, but you should be able to do it if you are not an immigrant without the help of a lawyer as well. Thanks, everyone.
Thank you, ma'am. Now, the first thing we're going to do is I'm going to thank each and every single one of you for all of that information. And I want to make sure, since that slide went by so quickly, that we focus a little bit on what each organization, the contact for each organization. There's a lot of information that we have shared today, and there's a lot more than we will share in the Q&A. But as in most of these cases that require legal assistance, please contact these folks if you have questions. And maybe your case is so specific that it would require some specifics. So that's why these are up. So first of all, from the Bronx Defenders, Eli Northrup, even if he's not available, I'm sure that there are a lot of other folks that are available. That's the way to contact them, 718-838-7878. Then we had Jose Chapa from the Immigrant Defense Project and La Línea de Ayuda de Inmigración Criminal, right? The line for help with for the criminal immigration helpline, 212-725-6422. You also see how to get them on the Twitter sphere and the gram and everything else. And last but certainly not least, Ms. Goldman, who was just was speaking from the Legal Aid Society. And the way you get in touch with them is 212-577-3300. I will take this opportunity to also just say very quickly that on this issue, or on many other issues, you might want to contact my office. The way you do that is 718-933-2034. And you should know, we are now open again. We are welcoming constituents back in on a limited capacity. We're doing it by appointment only, but please call my office. We are continuing to be open for you on this issue or on any others. All right, so we have a couple of questions that we want to answer here, and some which have already been answered, but they've been answered on I want to make sure that they're answered live, because this is going to be for the future. It'll be recorded on Facebook. So we want to make sure that we get it on here. The first one comes from an anonymous attendee. If in possession of amount above the legal amount, will you be able to voucher your cannabis and get it returned once a fine is paid? And Ms. Goodman, I believe that you had an answer to this one.
I did. So if you possessed over the legal amount, so an illegal amount, then you're going to have trouble getting it back, just like you did before. If you possessed under the legal amount, so a completely legal, not even a violation, then you should be getting it back. We have yet to see if they will actually return it, because the police don't like that. But it's completely legal. If you possess or sell, if you possess under a certain amount, it is completely legal. There is no crime. It's not even a fine. So you should be getting that amount back if that's what's happening.
Thank you for that, Ms. Goodman. There was another question that was answered live that is related to NYCHA residents being able to home grow. And we talked about the fact that because NYCHA, the New York City Housing Authority, is a city agency, but they receive federal funds, there will be a determination that will be made by them about whether home grow home grow is allowed. But if you are in your private residence, in your personal residence, Austin Messiah asks regarding homegrown, if the household contains 3 people, how many plants can be grown? It is my understanding that the number of folks who live in the home is not necessarily a limiting factor. Is that correct, Eli?
Well, the way the law is written, each individual can possess up to 3 mature and 3 immature plants, but there's a maximum cap of 6 mature and 6 immature plants per household. So if you have more than one person, essentially you can possess 6 immature and 6 mature plants. If it's just one person in the household, it's 3 and 3. However, I want to be really clear that these home grow provisions are not in effect right now. They won't go into effect until the Office of Cannabis Management promulgates guidelines on home grow. So at this current moment, home grow is not allowed, and the maximum you can possess legally in your home is 3 ounces.
And that's actually a very good distinction that needs to be made. As Eli stated right up front, many of the things that we're talking about are in effect, everything related to odor, relating to possession, to use, etc. But there's some things that for which regulations have to be created, and in particular the home grow as an example, and that is not yet in effect. And I will remind everyone, there is an appointment or a few appointments that have to be made by the governor on this issue. There's some folks that have to be appointed, and there's many of us who are requesting for the governor to send us some good names. There are some conversations that are ongoing. I hope that they continue, because we want to make sure that the folks who are appointed to these positions are folks who care as much about all of us right on the screen right now, or other folks who voted for this. We want to make sure that we have that folks that are going to create the regulations for this are folks who care about social justice at the core of the project. We can't have folks that are going to potentially don't know anything about New York, or might not know that much about the marketplace, or might not have that social justice at the core of it. So we want to make sure that we get the right folks. And I'm sure that in the continuing conversations that occur between the governor and the legislature, we will get to that. But again, there's some things that are in effect, some things that are not. Now, there was a question here that was asked by Rocio Sumaya, and I'm not sure I understand it too well, but I'm going to try to tackle it. Rocio Sumaya asks, how can we support the youth under 18 years of age for the use of cannabis in the community? There's a couple of things there. First of all, the concern always was, we call it adult use cannabis for a very good reason. Very much like we do for cigarettes or for alcohol. The concern here is that if you're a responsible adult, you should be able to make the decision about whether you use something or not. And so we created, there's actually significant restrictions on advertising of adult use cannabis, particularly to children. And much like we have for cigarettes, there is a banning of advertising on adult use cannabis on mass transit or near schools. There's banning ads that make claims about the medical uses of adult use cannabis, although I'm hoping that eventually we can, with research, establish the medical benefits of it. But in any event, there is much that we did to make sure that this is something, again, you should be able to make a decision as an adult about whether you have access to something, and as long as you use it responsibly, which actually goes to what we've talked about as far as being in your car or other things like that. We want to make sure, I do not have the ability to get drunk and then get in a vehicle and drive it. And that is something that we all accept as a given. So the same is true here. So we want to make sure that you have your home, make sure that you have it on your home. Let me see if there are any other questions. Actually, just and to say one thing again, as far as the things that we very broadly that we discussed, right? We talked about the things that are currently in effect and the changes that were made to the law. Because remember, for many of us, the reason that we did this, the reason that we voted for this, is that we knew that even though white communities and communities of color used it at about the same rate, and this has always been the case, the reality is that the criminalization of it has happened mostly in communities of color. And that means that the drug war, if we call it that, has been harmful incredibly to communities of color. That is what we're trying to solve here. That's what we're trying to pull back. And we understand that there's some folks who because of the way that we've always perceived drug use, and in this and or marijuana in particular, there are some things that we might have a little bit of difficulty from. I've had conversations with some older constituents who have an issue with the odor, for example. But the reason why I'm glad that we discussed it today is that, as we know, it has been used at times, again, to criminalize certain communities at a much higher rate. See, the use did not correspond to how much folks were criminalized. So that's why changing these is important. And we need to create the environment to be like, listen, if you're gonna, just like having cigarettes, I used to be a smoker myself of cigarettes. I'm not a smoker now, of, like, just for the record, not a smoker of marijuana because it's not my thing. I have inhaled, but I don't like it. If you do, God bless. I'm more of a spirits guy personally, but that's neither here nor there. But we want to have it in designated places, and you should be able to do that. You should not be criminalized because of it, and that's why these changes are necessary. But there's also the immigration issues need to be underlined here. The conditions for our immigration system, which must be fixed at the national level, has a lot of caveats here, right? And so therefore, folks who have immigration issues should be very weary, and having a conversation with folks like the Immigrant Rights Project or whomever, an immigration's attorney that you have access to, or perhaps calling our office so we can connect you to folks who can answer these questions. You should be very weary, because the conditions are going to be a little different for you as a person who has immigration. If you have immigration issues, the standards are going to be a little bit different. And last but not least, on the issue generally of expungement, just underline again that you do not want to fall into a scam. You want to be able to, there might be some instances in which you might require some assistance, and that could be provided by organizations like Legal Aid Society and others, not somebody that says like, hey, give me $1,000, I'll get rid of this for you, buddy. I'll take care of it. That's a scam. Do not fall for it. Okay, so those are some of the top line things. Let's see here if we have other questions that popped up. Let me see if I'm waiting for my staff to put something here on my chat. All right, here we go. This is from Patricia Brantley. Where can I legally consume cannabis today? Now, I know that we've talked about this. We talked about this already, Eli, but if you could actually go over it again, just to give us a brief overview of that again.
For sure. In terms of smoking cannabis, you can smoke cannabis pretty much anywhere that you can smoke a cigarette. So if you could smoke a cigarette on the sidewalk, on outside, in your own house, as long as your apartment doesn't prevent you from smoking inside, you can smoke cannabis. You can consume cannabis in other ways, in other places. So there's no prohibition of consuming cannabis in some of these other locations. You just can't smoke it. There will be there's a provision in the bill that will provide for on-site consumption licenses. So that contemplates lounges, bars, essentially, for cannabis. Now, not places that serve alcohol and cannabis at the same time, but a specific place where you can go and consume cannabis on site. Because obviously, as we mentioned earlier, the federal government still has some control over public housing. It may be illegal to consume in some of these spaces. So we need to provide for actual safe spaces for people to consume. So eventually there will be lounges, places that people can go to consume. But for now, outside, any place you can smoke a cigarette, you can smoke cannabis.
Gotcha. And Jose, would that be the same? Are we talking the same if somebody is an undocumented person, for example? Is that also the case for an undocumented person?
Again, not to let folks, folks decide what they want to do and what they it's up to them. But federally speaking, since federally marijuana is still illegal on that level, proceed with caution. As I mentioned during my presentation, if you are going through application processes or you are in deportation proceedings, this will come up, and you are under oath when you answer questions. So these are it's more sensitive when you're undocumented and you're an immigrant, unfortunately.
That's what I wanted to underline. So folks need to be, because what we're trying to do here is provide as much information as possible. And certainly, adults make their own decisions, but you should know that this is the case. If you are in proceedings and you will be asked to be in places where you will be asked to speak under oath, then make sure that you are wary, just be careful about what you choose to do, because then if you have to answer questions about it later, it might certainly impact whether you go through the proceedings successfully or not. So that is something to consider. I don't know if you have anything to add, Ms. Goodman. All right. Okay, we have a couple more here. Now this actually is an important one, because it actually speaks to the fact that this is something new, something that we've just established. There's many of us that have been fighting for it for a while, but this is changing the status quo in a very fundamental way. And Naki Cruz, I hope I'm pronouncing your name correctly, Naki. How might law enforcement and community interactions be affected, like stops for suspicion or driving under the influence? So, Eli, if you could talk a little bit about that particular. So, underline that again, since I know that you've talked about stops for driving under the influence. But then have a general discussion about how we think that this is going to impact the law enforcement and community interactions. But on that one first, on the second one first.
Of course. Well, I mean, I think one thing that we've already seen is the day after the MRTA was passed, the NYPD sent a memo out to all officers, basically analyzing the law and the odor provision that's in the law specifically. And in doing it, the NYPD essentially said, look, you can no longer just use the odor of marijuana to search somebody's entire vehicle. So even if you pull somebody over under suspicion of driving while impaired by cannabis, the law limits where the search can take place to finding evidence that's actually associated with that crime, driving under the influence, right? We've seen for many years, police officers use the odor to basically search entire cars, tear them apart, search everybody in them. The NYPD has acknowledged that they can't do this anymore. So they also don't seem to be very happy about it. There's been articles with NYPD officers quoted as saying, this is taking away a tool. This is taking away a tool of ours. But the fact is they were using that tools in a very racially discriminatory way. And the data bears that out. Senators, you mentioned, as early as recently as a couple of years ago, over 90% of the arrests for marijuana in the city were for people of color, despite the fact that people use marijuana at equal rates across races. So that tool was taken away from the NYPD because they were not using it in an equal manner. And it also is because marijuana is now legal, it doesn't make any sense for them to be able to use the odor to harass people. I would hope that it would hopefully, by preventing these kind of just blanket searches and harassment based on the odor of something that's legal, that will improve law enforcement community relations, because people won't feel targeted for something in a way that, but I don't know that I'm confident in saying that will actually happen. Right. In my experience, when the NYPD is faced with some sort of barrier, they try to figure out a way around it. And I'm speaking only from my own personal things that I've seen. But I guess that's my best answer to that. And I don't know, Emma and Jose may have other things to add.
I definitely would love for them to add, because it is a work in progress, right? So but I know that there's difficulty. Ms. Goodman, you were about to jump in.
I was just going to say, I'm hopeful too, but also skeptical. The language in the bill, especially about the police not being able to stop people based on the odor of marijuana, and just to be clear for everyone, this is on the street as well as in other places. So if you're on the street and you're smoking, the police can't stop you just based on smelling the marijuana. They can't even stop you if you're legally smoking a joint on the street. It's not illegal anymore. They can give you a ticket and they can walk away, but they can't search you. They can't go into your pockets. It was essentially stop and frisk after stop and frisk was supposed to stop. And the language that was in there, the public defenders that were part of this coalition and the directly impacted people that were part of the Start Smart coalition that really were working in support of the bill, thought that language was really, really important because we thought it had the potential more than anything to change how much police harass people of color in New York, especially. Again, whether that actually happens, we'll wait and see. But it is a huge tool, and it was the main thing that the NYPD used to stop and harass, especially young men of color on the street. And they can't do it anymore. So we'll see what they do instead, but hopefully it does limit those potentially very dangerous interactions from happening in the first place.
Gotcha. Chapa, go ahead.
Just to add to that, also keep, even though again, yes, it is legal in the state of New York, but some quick examples. If you're coming back from Canada, since we're close to the border, up north, if there's a border patrol checkpoint, border patrol agents are federal agents, so they still have the ability to search your car, even if you're a citizen. That could get you in trouble federally, especially if you're not a citizen. And then at airports, if you go to an airport, that's technically a federal agents as well that you're going to be encountering. So I think they're still figuring out like what. I am not too keen on this, but earlier, like 2 weeks ago, I might have heard that they're no longer searching for small amounts of marijuana, but I don't know if that's taken effect yet or what's going on with that. I'm not sure if Eli or Emma have any news on that.
Yeah, I would say if you're going in an airport, even if you're traveling from a state where it's legal to a state where it's legal, you're still taking a huge risk.
I was going to say, if you're going to Colorado, enjoy your time there.
Right.
And then just get on the plane with your wallet,
right,
your bag with just clothes and what have you.
Right. If it's legal where you're going, you don't need to bring it with you anyway. So yeah, when you're crossing through an airport, no matter what, it's a federal jurisdiction, and obviously it's still, as we've talked about, illegal on the federal level. Jose, I'm not exactly sure about their guidelines on that, but I would just say it's a big risk to take to transport cannabis, even if you're going to a place where it's legal from a place that it's legal.
Certainly keep that in mind. But one thing actually that since there is in the state of New York, one of the things that the bill did related to the selling of it, which again is not in effect yet, that is going to go into effect once the cannabis board is created and all the regulations, et cetera, et cetera. There are different localities where they will opt out of sales. Does the law of being able to smoke, as you said, or use it or possess it, will it be different in those localities? So that means that that even though they have opted out of it and they've opted out of the revenue, hint, hint to some localities out in the state that are choosing to do that, you can still, as a resident of that town or that locality, take a little trip within the state, come down to the city in a few, next year at some point when this thing is in effect, and purchase it, then bring it back up to your home or bring it out to Long Island, whatever, and have yourself a merry old time.
That's right. The penal law is a statewide law. So, that the possession penal law offenses, you're allowed to possess up to 3 ounces everywhere in the state. It's not like a municipality can say, we're making it illegal here to possess it. There's no opt-out for that. The opt-out is only for that licensing scheme and the sales.
And actually, we talked a little bit about this earlier, but excuse me, this is from Facebook. Isleida Santana, who asked how to prevent our young people from starting to consume cannabis below the age under 21. And I would argue that it's very much like what we do for type of things that we have to do is both for alcohol and cigarettes. We educate people about the impacts of these substances. I mean, certainly, I try everything I can to make sure to let people know that smoking is something that will kill you. Smoking cigarette. I used to be a smoker myself, but certainly I'm very aware of the types of cancers that you can get from it, the type of things that you can have, the impact that it can have. Also, I mean, when you think about it, the potential health impacts that are there for either cigarettes or alcohol are actually much more serious than anything that's been demonstrated from cannabis. That being said, the law is very clear. Here we're talking about giving the ability to adults to make adult decisions about things that they can responsibly enjoy. There's no reason why you can't go to the corner store and have yourself a pack of Marlboro 100s, get a nice 6-pack of beer, bring it back home, and then then you can have a joint as well. That is basically what we're saying. This is not about encouraging anybody to use. This is about creating a situation in which we take away, as Eli said, and I think very smartly, this tool that was utilized by law enforcement, which was used for a very long time in a very discriminatory way, taking that away and saying, hey, if you're a responsible adult, you can have the choice to do this. And again, someone like myself, once the thing becomes legal, I mean, it is legal now, but once I have somewhere to purchase it, I'm still not going to do it because I don't like it. I'm going to enjoy my spirits and be done with it. But we want to make sure that we do not criminalize and certainly over criminalize certain communities for doing the same thing that other communities do. All right, so I think
Senator, on that point too, I would just say one of the intentions of the law, and as you've seen this in other states, is that a regulated market should actually be a lot safer for people, because there's going to be regulation of the substance that you're purchasing. It'll be subject to testing and subject to make sure that like what you're actually consuming is safe. You'll be able to get more information about it. So in a way, regulating a market should actually make it safer for everybody who's consuming and more educated on it.
I mean, you get carded when you go to the store to get some cigarettes. They will card you there. So, or if you're getting a 6-pack of beer, so it would be the same process. So I think so. Let me see if there's another question here. Yeah, there's one more from Gail McLean, and you answered this earlier, Eli. Is there a legal weight for consuming and selling? And I would say that the selling part is still, it has not been worked out yet. But as far as consuming or at least possessing, there is a standard, right?
Yes, at this moment, it's 3 ounces inside and outside of your home is totally legal for adults over the age of 21. Eventually, you'll be able to possess up to 5 pounds in your home once the home grow provisions take effect. And in terms of selling right now, if you sell up to 3 ounces, it is a civil infraction. It's a violation. More than 3 ounces becomes a crime. But as the senator mentioned, it's not legal because there's no licenses right now.
There you go. Well, folks, we have all the questions, at least the ones that have been asked here, have been answered. So I will say, I will just repeat a couple of things and then we'll bring it home. Again, the purpose of this whole bill is to make sure that what had happened for many, many generations, and unfortunately is still happening in many places across the country, where the use of a substance by 2 different communities is treated very differently. And the impact of how it's treated in particular communities are intergenerational. The drug war has actually impacted communities, certainly like the ones that I represent and the ones that all these folks work in a way that has been disproportionate. And we need to make sure to fix that. And so that is what we're doing here. And I'm incredibly proud of the bill that we passed in the state of New York, because it is a model law. It is the type of law that doesn't just say, we're just going to create a marketplace so we can make some money. Like, let's think about the impact that the drug war has had on people before this bill passes. This is where the expungement comes in. We can talk about the impact that we can have now on creating a marketplace which creates economic opportunity, including for people who are involved in the illicit trade. And as it moves forward, once the revenue is generated, then a chunk of it comes back to the communities that have been harmed by the drug war for a very long time, which is the reason why we passed this bill. And implementation is always, the devil is always in the details, and nothing can be perfect. But it's certainly, I believe that the bill is an excellent bill. And with folks like these great advocates, Ms. Goodman, Mr. Chapa, and Mr. Northrop, and all of you out there, we're going to make sure that we get it implemented in the correct way. So I will do one more time. I will put up on the screen the names of the organizations and the contact information to make sure that you know how to contact them if you need them. First of all, my office, if you need us for this or anything, 718-933-2034. And as I said, we are now kind of by appointment, but we are open again. So we're certainly looking forward to saying hello to you in person. And if you want to connect with us on social media, you saw the gram and the Twitter and what have you. But if you want to contact the folks over at Eli Northrup's Bronx Defenders, one of the great organizations of this borough, 718-838-7878. If you want to contact the folks at the Immigrant Defense Project, and we're certainly joined by Jose Chapa today. Thank you so much, Senor Chapa, for being with us. And that is the 212-725-6422. And I know there's one more question, but we want to get through this whole thing. And then the third one is if you want to get in contact with the folks at the Legal Aid Society, you can contact them at 212-577-3300. And it seems that the Legal Aid Society is actually going to bring it home because there is one more question. And the question is from an anonymous attendee. What about those who are currently incarcerated for marijuana offenses? That's a very good question, anonymous attendee. Ms. Goodman.
Yeah, very good question. If the person has a conviction that is eligible for automatic expungement, they have already been released. If somebody is serving time on a parole or a probation sentence for something that's eligible for automatic expungement, they have already been released. If somebody has a conviction for something that isn't eligible for automatic expungement, but could be eligible for getting your conviction vacated or reduced, the state has been working and has made a list of those people and is going to connect them with lawyers like me and other lawyers around the state to make sure that they file those applications to get out as soon as possible.
All right. And on that note, we will say thank you again for all of you folks who attended this evening. Thank you to Emma Goodman, Eli Northrup, and Jose Chapa, as well as our translators, whose names, let me see if I can get them, our interpreters, I should say. And the interpreters, what are their names? That is, I don't have their names right now. I think Isaac is one of them, and Lebe. I'm pretty sure I'm mispronouncing your name, but thank you so much. Lebe Diaz and Isaac, whose last name I do not know, but thank you both of you. Thank you to all who have attended. Make sure that if you are interested, as I said earlier, in the business part of this and potential economic opportunities, we had a whole other town hall speaking directly about the economic opportunities, and it is online, so you can go and see it. And you will be able to have this one also living in the intertubes forever. But for this evening, I will say thank you again for being here tonight. Thank you everyone for attending, and have yourself a very pleasant and safe evening. Wear a mask, folks. Wear a mask still. Do it. Have a good one.
Thank you.